Good evening, everyone. I welcome you all to our webinar titled Evolution of Privacy and Data, New Age Industry Issues 2022. Let me now introduce the speakers. For today's session, we have Huzefa Tawawala, Head, Disruptive Technologies and FinTech, Nishith Desai Associates. Aaron Kamath, Leader, TMT and FinTech, Nishith Desai Associates. Indrajit Sarkar, Leader, Public Policy and Regulatory, Nishith Desai Associates. Anirudh Majmudar, Member, Tech, Media and Disruptive Technologies Practice, Nishith Desai Associates. Purushottam Kitane, Member, Technology, Telecom and Data Protection, Nishith Desai Associates. And Varsha Rajesh, Member, Pharmaceutical, Healthcare, Medical Devices and Digital Health Team, Nishith Desai Associates. I welcome you all here, and now I would like to hand over to Huzefa. Thank you.
Thank you, Dipshi. Thank you for the kind introduction. Welcome all. Good morning, good afternoon, good evening to all our participants who've joined in across the globe. This is a really interesting and exciting session because the focus is evolution of privacy and data, but the fine nuance is that we are going to focus on key industry and new age issues. So not only are we going to give a flavor of the federal proposed law, but more importantly, also going to discuss the updates which have specifically happened, the sectoral updates which have specifically happened, for certain 4-5 key industries, namely digital payments, e-commerce, a little bit on the healthcare and life sciences front, geospatial laws, and more interestingly, with the entire convergence happening machine to machine and IoT. And what you all should be aware of, basis these data regulations which have come in. On that note, let's dig in right away, and I'll ask the first question to my colleague Indrajit. With the data protection bill, we know that it's in the annual, it's going to be enacted sooner than later. Once the bill is, formally enacted as law, Indrajit, what would change in terms, for businesses, especially from an operation and implementation? And you can also, spend 30 seconds giving our audience the status of the data protection bill. Over to you, Indrajit.
Thanks, Josefa. I think in terms of status, it's a big moment. At least we as lawyers practicing privacy and data protection have been waiting for a good part of like the past 3 years. We understand that it's now sort of imminent with the JPC's report and the new revised data protection bill that was sort of released earlier last year. And MeitY is quite confident that they would be looking to table this bill in the upcoming budget session. So yes, there is a sense of urgency. Now, in terms of what really changes from the current regulatory scheme under the IT SPDI rules and this data protection bill, I think the first headline item here is the scope and applicability. And by that, I mean both in terms of the scope of data that is covered by the data protection bill, as well as the regulated entities that would need to sort of abide by the provisions of the data protection bill. Now, the SPDI rules, which the industry is broadly familiar with by now, since it's been in force since 2011, provides an itemized list of certain kinds of information that is considered SPDI, and it includes passwords, financial informations, medical records, and the like. Contrast that to the DPB, it now aligns itself to a much more European-like conception of like PII. So personal data now includes a wide gamut of data, which could basically be used to identify a natural person, and most importantly, includes any inference drawn for the purposes of profiling, and profiling being any sort of analysis or processing to study or predict behavior attributes or interests of a data principle. So clearly the scope there has widened significantly. The second thing is that unlike extraterritorial applicability, I'm
Better.
hoping
Thank you.
that's better. All right. Yeah, so I hope I was audible for the last part where I was sort of touching on the extraterritorial applicability bit. And I think a third major change that has really come about in this recent iteration following the JPC's report is that in the earlier iteration, they had a carve out for anonymized personal data, but that carve out has been expressly deleted because the bill is now extending its scope to non-personal data as well in some limited ways, which we can touch upon later. But apart from that, I think a major differentiator, as opposed to the SPDI rules, is the fact that the DPB explicitly spells out certain rights, certain statutory rights that data principals will have, and the obligation to sort of enforce those rights is being vested upon all data fiduciaries within India, who are subject to the provisions of the Data Protection Bill. And these extend to the right to data portability, where I can request the data fiduciary to port all my personal data that's been used and processed by them to another data fiduciary in a easy interoperable format. This could extend to the exercising the right to be forgotten, where I insist upon deletion of my personal data when, on a balance of competing interests, it is determined that the data can be deleted without affecting the right of other people to know or have access to that data. And also other rights such as the right to correction and erasure and the right to correction and erasure. So I think the rights-based approach is again like a major change that has been brought in. And I think one last point that I would like to touch on before I would probably have also put a weigh in on this, because we did look at the bill with a close to a fine-tooth comb earlier when it was released. One very major change that has happened here is the data breach provisions, where earlier, in the event of a personal data breach, data fiduciaries would have had the chance to sort of evaluate the real impact of it and determine next steps on their own. The new bill sort of makes it mandatory for businesses to report a data breach to the proposed regulator, the Data Protection Authority, within 72 hours, leaving very little autonomy and wriggle room for the data fiduciaries to actually wait and assess. But it's now a more sort of straight linear triggered mechanism where the moment there's a data breach, you report to the Data Protection Authority within 72 hours, and then you work with the Data Protection Authority to figure out how to mitigate and whether or not to disclose, and that is subject to the regulator. So I think these were the main points that I see as key differentiators. I think maybe others can also pitch in, Josefa.
Absolutely. I think this is really helpful, Indrajit, from a context setting perspective. I think you've absolutely laid down the tone from a rights-based approach, towards a breach notification requirements. Keeping that theme in mind, and before we kind of dive into the more industry issues, it would be great if my colleague Purushottam can step in here and give us a little bit of a flavor in relation to the compliances for local storage and sharing basis the DPPB. Over to you, Puro.
Sure, thanks, Josefa. So there have been some changes in the latest version, although the broad position on how data should be localized or say mirrored or can be transferred freely outside India is maintained. One is what organizations will also have to keep in mind is the basic classification itself of personal data, sensitive personal data, and something called critical personal data. Now, in personal data, of course, it is freely transferable. There are no restrictions per se under the data protection bill that is being maintained. In sensitive personal data, of course, there has been a mirroring requirement that is put in place. While SPD or sensitive personal data can be kept as a copy in India, it can be transferred outside. However, this sensitive personal data should also be kept in mind that there are some restrictions sectorally. So while depending on which sector the transferee of the data is, the restrictions under the DPB once it is enacted will also parallelly play in with the sectoral regulations. In fact, the Joint Parliamentary Committee report also suggests that the central government should actively consult sectoral regulators in determining what can be in determining what restrictions will apply for the restriction for sensitive personal data. So the basic point is that once the DPP is enacted, it's not that sectoral regulations will go away. In fact, we will probably see more sectoral regulations in line or parallel with the restrictions on SPD transfer. Then the third classification of data, there is of course the critical personal data. Now that is not defined under the data protection bill yet, but it is supposed to be left to the government to define it. But of course, there is a hard data localization requirement, unlike sensitive personal data, which is a soft data localization requirement. Critical personal data cannot be transferred outside India. But with these restrictions, certain questions do come up, which is that one, we will have to make sure if any organization that is processing data will have to strengthen their data mapping, data identification exercises because of this classification. So keeping in line with this classification, there are certain problems that may come up, of course, because we have seen a lot of organizations also use mixed data sets, which contains personal data and say some amount of sensitive personal data and presumably critical personal data once we know what it exactly is. So when there are mixed data sets, there has to be special consideration on what can be or can't be stored in India, what can be mirrored, and what is freely transferable. So these processes have to be streamlined. And another consideration that is kind of lacking or that requires more clarity in the data protection bill is the data which is collected by foreign entities directly. If this contains sensitive personal data, whether this localization requirement or mirroring requirement will apply to these foreign organizations collecting personal data from Indians directly. Now that has to be again looked at with the extraterritorial applicability of the bill that my colleague Indrajit just touched upon. These are certain localization requirements. Of course, there are some transfer restrictions also. For example, even when you're transferring sensitive personal data, you have to there are some processes there are some compliances that have to be satisfied. One is, of course, the basic requirement of explicit consent from your data subjects. Now, once that along with that explicit consent, there are 2-3 methods through which these sensitive personal data can be transferred out. One is a contract based on a contract which is approved by the DPP, but of course with consultation with the central government. This would include your intra-group transfers. But again, these schemes, of course, has to be approved with the data protection bill. One aspect that is new and quite noticeable in this version of the bill is that it is dealt with in consultation with the central government. So it is not a clear-cut approval. The central government also weighs in on a country or an organization which can be designated by the DPA, the Data Protection Authority, on which sensitive personal data can also be transferred. And the third way on which data can be transferred outside India, along with explicit consent, is there a specific purpose for which the such transfer is allowed. Now, these are just restrictions on transfer that are applicable. But of course, this also has to be seen. This has to be seen with how critical personal data is defined. What is the consultation process with the government? Extraterritorial applicability. This is a kind of a holistic view that you'll have to take when data is transferred. That's on transfer and localization from my end, Josefa.
Absolutely. I think, again, the insights are very helpful, Purushottam. The key takeaway for our participants and our audience is that while we await the DPB and the restrictions on transfer and storage, what is more important to understand that sectoral regulations in terms of such restrictions shall continue. So when the DPB comes in also, it could be a situation that the data protection law will be the base compliance levels and the sectoral regulations will be stacked upon. So I think this is a very key and interesting nuance. And with that note, let's get in more from an industry perspective. And I come back to you, Indrajit, specifically from a digital e-commerce perspective, right? Once we see the DPB kind of getting enacted, what do you see are the broad takeaways? Taking the e-commerce industry with this backdrop.
Certainly. Thanks, Josefa. And I think, just as I said, as an with the e-commerce players, I think we are looking at a wide variety from big and small players, some of whom might have already had an experience with complying with the GDPR. But I think there are a lot of key crucial points that need to be considered by businesses after the DPB is sort of enacted. Obviously, the widened scope of personal data and differential requirements applicable to sensitive personal data and critical personal data would mean that you would have to place significant amount of time and energy in sort of understanding what data you're acquiring, why you're acquiring, how long do you need to retain it, because along with all that data comes a cost of compliance. I think the second point that really is going to be a pain point for a lot of players is that not all e-commerce players really handle all the data processing activities in-house necessarily, and they do have to work with third-party vendors and third-party plugins. And there needs to be this reassessment whether, even if for their best endeavors of complying with the data protection bill, whether these third-party vendors and their products and plugins are actually compatible with the DPB. So a lot of e-commerce players, for instance, would be using stacks like Shopify or something like that, and there needs to be this sort of credence given to the data classification that's been provided under the DPB. Lastly, I think one of the workarounds that could have been available earlier was actually just straight up anonymizing a lot of the data for the purposes of marketing insights and drawing inferences. But I think now, with anonymized data being explicitly left out of the scope of being included within the scope of the DPB, I think, and coupled with the additional provision which enables the government to mandate sharing, I think there's a lot more that needs to be considered in terms of just the strategic considerations in terms of anonymizing this data, retaining non-personal data sets, and what would be the cases under which the government could ask for this data, and how what the government does with it from that point on. Obviously, the bill does provide some indications in terms of the limited purposes of, direct delivery of benefits, better delivery of services, but that's still fairly wide and leaves much to be clarified.
No, again, this is so helpful again. So we understand, this is a slightly, we know the law is going to come, but these insights are really helpful in just giving an audience a perspective as to how do you anticipate, prepare, and once it rolls in, the people would need to deliver. With keeping this in mind, let's shift gears. Let's talk about sectoral regulations which are actually existing, which are independent of the data protection bill. On this note, let me move on to my healthcare, expert, Varsha. Varsha, we understand that from a healthcare and life science perspective, data is absolutely critical. But more importantly, it would be great if you could give us some insights, from a healthcare sector perspective. Are there any nuances or compliances which apply, to sectoral regulations to this industry? Over to you, Varsha.
Thank you for the question, Josefa. And as rightly pointed out by you, data in the healthcare industry is extremely vital, and immense data is collected through various applications and contexts, such as in the form of medical records, clinical research as well. Now we see a digital health evolution wherein we have wearables and health applications which generate immense amounts of data. So in fact, to take two steps back, the concept of confidentiality is almost synonymous with healthcare, and confidentiality has always trickled down into a lot of healthcare laws across the globe. But however, the reason why there's so much discussion surrounding health data protection today is because we have grown so much from the traditional healthcare system where healthcare is no longer confined to a doctor-patient relationship, but instead there are lots of other ancillary healthcare services that we see today. So when we speak of regulation of health data, we need to look at it from three angles, specifically with respect to India. So the first is how health data is regulated today. And the second is how the present day regulation is set to undergo a drastic change. And lastly, how health data regulation is shaping and what we can expect in the context of the DPB. So first, I'll spend a couple of minutes talking about the present day regulations. So as Indrajit rightly pointed out, we have the general law in the form of the IT Act and the data protection rules issued under it. So under the general framework itself, health data is currently categorized as sensitive personal data. And therefore, there are certain restrictions in terms of its collection, transfers, and processing. For instance, you need to seek consent to collect health data. And also, institutions which are collecting health data must ensure that reasonable security practices are implemented. But I won't be going into the specifics of it because we're quite aware of how it has been operating since the law has been in place for more than 10 years now. But something that I'd really like to take time with is explaining what are the sector-specific laws which actually govern health data today. So proceeding to the duty of confidentiality itself, the first law that I'd like to talk about is the Code of Ethics, which is issued under the National Medical Commission Act. So this specific Code of Ethics basically applies to all licensed healthcare professionals. Essentially, a licensed healthcare professional in India would be anyone who's registered with the government to practice allopathic medicine in India. So under this certain code of ethics, there's a duty on placed on all of the licensed healthcare practitioners in India to follow a duty of confidentiality when it comes to dealing with the data of their patients and ensuring that they are not divulging any details of a specific treatment or treatment plan that has been rendered to their patients to any third party. So the second law that is very essential when we talk about health data protection is the Clinical Establishments Act. So the Clinical Establishments Act basically applies to all clinical establishments. For instance, this could include hospitals, clinics, nursing homes, and so on and so forth. And this basically imposes a responsibility on all clinical establishments to maintain electronic health records. But unfortunately, there's no clarity in terms of how health records have to be maintained and the manner in which the data can be retained, or what is the security that can be extended to electronic health records. And in addition to this, despite being a central legislation, this particular law, in fact, lacks teeth because of the fact that it's not applicable pan-India. So essentially what this means is, while we have a central legislation in the form of the Clinical Establishments Act, several states have chosen not to adopt this, and instead they've implemented their own Clinical Establishments and Hospitals Act. So some of these state acts, in fact, do not even have an obligation to maintain electronic health records. So the last bit with respect to the present day sector-specific law in terms of health data would be the electronic health record guidelines, which has been issued by the central government. So these specific guidelines, in fact, provides greater clarity in terms of what health data is, and also discusses certain standards of security and practices which may be applied to health data. But and also discusses the fundamental question of ownership of data and provides certain rights to the patients. But unfortunately, these guidelines are not issued under any specific law, and therefore they're not mandatory, but instead clinical establishments may voluntarily choose to comply with this. So this is where we stand at broadly. And I'd like to discuss a couple of key issues in terms of the present day data regulation. So the first being that healthcare establishments, which are not a body corporate, will automatically fall outside the ambit of the general law. So when I speak about the general privacy legislation, I'm referring to the IT Act and the STDI rules, which categorizes health data as sensitive personal data and also imposes certain obligations on body corporates to comply with, which I just previously mentioned. So a healthcare establishment, which is not a body corporate, will not be bound by the general privacy regulation itself. So for instance, if I am an independent healthcare practitioner, like a doctor with my own clinical setup, I will not be bound by the duty of confidentiality and the security practices which has been laid down in the general privacy regulation. So in line with this lack of uniformity, the second challenge that is posed in terms of how health data is regulated today is the lack of uniformity within how the clinical establishment framework itself is applied across India, because of the fact that the law itself, which provides for electronic health records in India, is not universally applied across the entire country. What we see today is that there is no real obligation upon a lot of clinical establishments to maintain electronic health record. So the question of providing for the security and privacy of patient records itself does not arise, and the obligation is more on a voluntary basis right now. And the third being, because of the fact that the present day laws specifically only intend to regulate a traditional healthcare setup, wherein a patient goes to a hospital or a patient goes to a doctor, a lot of companies, which we see in digital health, in the age of digital health today, like technology companies which are in the business of wearables, health applications, are not obligated to maintain electronic health records or obligated to ensure the security and privacy of health data in a more under the sector specific laws, while the general laws may still be applicable to them. And in addition to this, the law today does not provide for the protection of any retained data, and also about how health data can be used further. And lastly, a lot of stakeholders within the ecosystem in terms of like data analytics companies actually fall outside of the ambit of sector specific regulations today, because most of the sector specific regulations are tailor-made for a traditional healthcare establishment, as opposed to taking into account several other ancillary services that have emerged in this industry. So while the present day law is very scattered, the government has in fact over the past few years taken an active effort to recognize that that there is a scarcity in terms of regulation, and there are lots of gaps within how health data is being regulated and conducted within the industry itself. So therefore, as a result of this, mainly I'd like to touch upon two main initiatives. The first initiative being the Digital Information Security in Healthcare Act, which was in fact a draft law which was introduced in 2018. And this basically laid down the governance mechanism for electronic health records and also any form of health related information, and provided individual rights to patients with respect to the data associated with them. So it also laid down the controls on subsequent uses and how data breaches in a healthcare context must be dealt with, and how any retained data can be used further. But however, unfortunately, this specific law was scrapped off to pave way for the Personal Data Protection Bill, which is currently known as the Data Protection Bill, because of the fact to avoid duplicity of efforts, and because of the fact that the general regulation broadly provides for these laws already. So now the second most relevant development that the government has come up with is the Ayushman Bharat Digital Mission, which was also previously known as the National Digital Health Mission. So this is something that was introduced in 2020, and it has steadily been gaining momentum, and quite recently, less than 6 months ago, it has been made applicable pan-India. So contrary to common perception, this Ayushman Bharat Digital Mission is actually not a law. It's more of like a policy initiative which seeks to create a digital health ecosystem in India. So basically, any healthcare institution, a digital health company, insurance companies, and any other stakeholder within the healthcare industry itself can choose to participate in this ecosystem. And the implication of participation in this ecosystem is that they would be governed by the policies issued under this particular infrastructure. So basically, why ABDM is extremely important is because the future of India's healthcare infrastructure will in fact be based on this digital ecosystem which the ABDM seeks to create. So basically, in our experience, we've seen that many industry players are very keen on participating and mobilizing themselves to align with all of the policies issued under ABDM in order to have a head start. So there are lots of things which are in fact happening in the ABDM space, but something that I'd like to discuss today right here is two very important policies which have been issued. The first being the Health Data Management Policy, and the second is the proposed Health Data Retention Policy. So, for the benefit of awareness, the health data management policy has been up and running for close to 2 years now. And the manner in which the health data management policy works is that it talks about the creation of an interoperable health infrastructure. So, what this essentially means is that every individual who signs up to participate in this particular infrastructure will be assigned a unique health ID. So with this unique health ID, the individual can visit different hospitals and have their medical records attached to this particular ID. So essentially what this means is that the medical records of of the individual itself is stored on a database which can be accessed by any participating entity. So the policy, in addition to providing for this, also creates a form of a consent-based approach where it lays down, where it provides certain rights to the individual itself, such as right of erasure, correction of their health data, and right to access their medical records. And in addition to creating individual IDs for common citizens of India, it also seeks to create individual IDs for healthcare professionals and facilities. So what this essentially means is that when there's a healthcare professional or a facility which is participating in the infrastructure, has a particular ID, when they intend to access the medical records of the patient who's coming to them, it will be associated with the ID. So essentially, this creates a form of checks and balance wherein the government is able to collate information with respect to access of healthcare records, as well as the manner in which these healthcare records are being corrected from time to time, and also the rights which are exercised by individuals. So now proceeding to the health data retention policy. So now proceeding to the health data retention policy, very briefly. So the policy is not yet in place, but however, there was a very interesting consultation paper which was released last December. So what we understand is that this proposed policy intends to deal with aspects of the period of retention and the security of the retained data, and also the further uses of the retained health data. So a colossal development in respect to this consultation paper is that it discusses the possibility of extending this proposed law to all healthcare entities and not just participating entities within the ABDM infrastructure. So this essentially means that every individual in India will be able to claim the rights which is provided for under the policy, and all healthcare institutions will have to comply with the corresponding duties. So while this is not yet set stone, it's something for the industry to be aware of, because we do foresee this happening in the near future. And while perhaps it could be implemented in a phase-wise manner, what we understand is that eventually the whole ecosystem will fall under the policy. So lastly, in brief, I'd like to deal with what is the implication of the data protection bill on health data.
So Varsha, we'll pick that up in the next question. Actually, it kind of segues into that.
Yeah, sure, Joseph.
Thank you. I think this was so very insightful and detailed. I think the key takeaway for our participants is that from a sectoral perspective, the regulated entities such as clinical establishments or doctors to a certain extent have obligations of confidentiality and storage obligations, but the gray area continues. Of course, the Omnibus 2011 data protection rules continue to apply, but non-regulated healthcare entities kind of fall outside the sectoral regulations, and which is where there is the intersection of technology and healthcare. And it is very interesting to see how things unfold, especially under the umbrella of the Ayushman Bharat digital mission. With this backdrop, I know there are a lot of Q&As which are coming on the chat. Please keep them rolling. We have factored 7-8 minutes in the end to kind of take a stab at all these questions. So please put in all your questions in the Q&A, and we will definitely get back to them. With this, let's also, we've kind of given a flavor from a healthcare perspective. I think the other sector which is really booming in India, and every second day there is something or the other written onto it, is the fintech and digital space. on to address issues of data storage, data restriction. I would like to call upon my colleague Aaron, who leads the fintech practice at the firm. Over to you, Aaron, for your thoughts and inputs.
Thank you very much, Josefa. The fintech space is one of the hottest sectors in India right now for various reasons. One of the most radical changes that was brought about, is over the last couple of years. Now, this was in light of a lot of reports, a lot of allegations of data breaches, of data compromises, of hacking, of breaches of security that was happening, so on and so forth. The Reserve Bank of India, which is, the apex, the regulator, the industry regulator, appears to have taken a consumer-friendly approach over the last couple of years. Now, let's see how that happened. That essentially started in 2020 when your payment aggregators, which are, your erstwhile payment gateways that facilitated the payments between users and online service providers, were effectively brought under a licensing regime. Now, more importantly, these regulations prescribed that merchants, online merchants, as well as the PSPs, the payment aggregators, cannot store card data. Now, this was introduced in 2020, and there was a certain timeline, that was prescribed. It was later clarified that merchants and payment aggregators cannot store card data. The only entities in the payment ecosystem that can store card data are your card networks and the issuers. The RBI went one step further and also said that existing data should be purged. There was a limited exemption that was prescribed, and that is that the last 4 digits of the card, as well as the card issuer's name, which is essentially the bank's name, can be stored for the limited purposes of transaction tracking and reconciliation purposes. So this was the limited exemption that was given. There were also some informal discussions that the BIN, which is the bank identification number, the first 4 or the first 6 digits could also be stored, but there's no official, confirmation on that. But what does this mean essentially? So there was an initial timeline of December 31st of 2021, which just passed. And with a lot of industry representation, this has now been pushed to June 30th of this year, 2022. But what does it mean for the entire online space, the entire e-commerce space? You see, this affects online businesses who now cannot store card data going forward, and they need to purge existing data. And we'll come to the purging in 30 seconds. But it also affects the entire consumer experience in terms of checkouts, because consumers were used to just choosing our card number which has been stored and using that as a mode of payment, or selecting a card number, just putting in the OTP and concluding the payment. This is set to affect the entire ecosystem in terms of how we check out, and more importantly, even in terms of our online subscriptions, to OTT platforms, so on and so forth. A lot of these things need to be redone. The RBI prescribed certain alternate solutions that could be undertaken for, merchants, PSPs to comply with the data storage restrictions, but also ensure some level of business continuity. Now, one obvious solution came to mind, which was tokenization, which was even, suggested by the RBI. There was a tokenization framework, which was existing, and the RBI expanded it to include, overall devices. The RBI even permitted card on file tokenization, which, was to be driven by the card networks. But essentially, an important clarification came out in December, the same circular which extended the timeline. And that said that in addition to tokenization, there can be other or alternate solutions that can also be implemented, right? So now we find ourselves in the conundrum, and we're working with, multiple clients on devising solutions like tokenization and hashing and alternative methods to ensure continuity in online transactions and essentially business continuity, both for the online platforms as well as for the consumers, right? There are certain issues that still need to be addressed, and 2 or 3 major issues which still require clarity, and there are industry representations being made, is that whether non-RBI prescribed tokenization can even be implemented in the first place, or whether there has to be RBI mandated tokenization, and in addition to that, can there be any alternative solutions that can be adopted, by the online merchants and digital service providers, right? The second one is that a lot of multinational merchants have also raised the issue on whether the regulations or the data storage restrictions actually apply to them. Now, this obviously needs to be evaluated on a case-to-case basis. If you have a non-Indian merchant who's offering a service in India, they may have onboarded with a foreign payment service provider or an Indian payment service provider. So accordingly, you need to see, the jurisdiction of the RBI, um, whether it's an Indian or a foreign PSP, and the applicability of the regulations, to them, to a certain whether the foreign merchant can even store the data or not. A big issue that also lies is with the data purging. Now, it's implied that all the existing card data held by online platforms and digital service providers, e-commerce, OTT, need to be deleted by June 30th, right? Need to be purged. But this is not clear that the entire data needs to be cleared, or whether you can still have certain identifiers or certain supplementary details, for fraud monitoring, anti-money laundering measures, so on and so forth. And the last one, and probably a big concern raised by the industry as well, is that, whether, or rather to what extent, the role the banks will play in terms of implementing this, because ultimately banks, process the transaction in terms of, the settlement and all of that, and whether there will be any push for them to implement the infrastructure so that all the other payment related entities, in the ecosystem can, work simultaneously and in harmony with each other to implement tokenization and other solutions. But there's a lot of movement in the space, a lot of new solutions, a lot of new business models, a lot of new complex but very interesting structures, that we're looking at, and a lot of hustle and bustle to get things into place and the transition smoothly, for the June 30th timeline. And with that, I'll conclude and back to Josefa.
No, this is again extremely helpful because there is a timer ticking from a compliance perspective, as you rightly said, which is June 30th. And more importantly, this is a unique sector, and I would like to reiterate this for all our participants, that this is such a unique sector where there is a sectoral regulation which not only has a data localization requirement but also has a data storage requirement. So these are the nuances which we want to bring about, which are very relevant from an industry perspective, and fintech being one. Thank you, and we will move forward to another very interesting and exciting industry, which is geospatial laws, or map data as we popularly call it. And this has a huge impact in today's world because there are various solutions and technologies which are embedding such data from a navigation or other perspective. For that, I would like to call upon our geospatial expert Aniruddha. Aniruddha, would be very interesting if you could give us some insights on this law and tell us if there are any restrictions from a sectoral regulation perspective and its industry impact. Over to you, Aniruddha. So let's do this. I think while Aniruddha is kind of fixing his system, let's move on to the next question, and then we can come back to Aniruddha. The other interesting, vertical specifically, which has sectoral regulations, which actually most people are unaware of, is machine to machine. With the entire conversion space happening with Internet of Things, converging various sorts of devices and human behavior and human interface, it is very important to understand if there are any telecom restrictions which are touch basing this particular industry. For that, it would be really helpful if a colleague and who's also an expert for M2M and IoT, Puru, it would be great if you could share some insights specifically, when machine-to-machine communications are happening. Is there anything which the industry should be wary of from a sectoral data compliance perspective? Over to you, Puru.
Thanks, Josefa. That was a very relevant point you mentioned, that although it is not, say, mainstream, there have been a lot of industry applications of M2M and IoT we are seeing. Of course, other than your classic examples of devices communicating in your smart home, to put it in simpler words, there has been a lot of applications across industry. We have seen logistics management, we have seen industrial plants, we have seen POS machines, we have seen utility meters, of course, and the most popular of all, we have seen automated cars. Now, all of these have some sort of M2M communications, but again, we have to make sure we distinguish between M2M communications that are over a telecom network as opposed to M2M networks that are just over the internet. For example, if I use my my smart bulb and I control it with my phone, that is just over the internet. But if I have automated cars which communicate to one another, say in traffic management, they will have something called as SIMs or eSIMs installed in them. As an example, now that is something which is something which is regulated by telecom laws. I'll keep this very brief because so that we can take up questions later. But how these cellular M2M communications, so to term it, is regulated is that there are certain there are certain laws which apply to telecom service providers, which provide a network to enable these M2M service providers, which means that if there are cars communicating with each other, and I take cars because it's the easiest example to understand, if there are cars communicating to each other, say via Airtel's network, to take a popular example. Now, the telecom service provider here will be subject to certain compliances, but what service providers will have to keep in mind is that there are certain obligations which the telecom service provider might pass on, which they are obligated to the government, to these M2M service providers or to these SaaS providers, which say provide an IoT platform for these communications. Uh, on a very high level, these compliances include certain KYC measures of the subscriber itself, which will be the M2M service providers. There are certain measures which there are certain details that you have to take of the end user. Say I'm the purchaser of a car which has an M2M, which is enabled for M2M. There are some details of mine that they'll have to take. So these are certain compliances that you'll have to keep in mind. But of course, primary compliances with the telecom service providers, which might be passed on to these M2M service providers, which will have to be considered.
No, again, these insights are so helpful because this is again a very unique industry proposition. When vehicles are talking to each other, and this is only getting more and more relevant basis the entire e-mobility industry which is being propelled, and where we are moving from normal cars, to smarter cars and to the smartest car, which is an autonomous car. These compliances and sectoral restrictions would get even more and more important. So thank you, Purushottam, for these updates. I think we have our colleague Aniruddha back. Just to kind of circle back, Aniruddha, would be great, taking lead and taking cue from what Purushottam said, that today an automobile sector has a huge deployment of geospatial or map data. And of course, there are other sectors in terms of navigation and digital tracking. It would be very helpful if you could give our audiences insights as to what is the geospatial and map law in India, and are there any sectoral data protection or data compliance nuances under this law which our audience needs to be aware of? Over to you, Aniruddha. Okay. I think we'll get back to Aniruddha. I think he's having a technical snag, but let's move forward onto the discussion. And I would like to come back to Aaron on this question. Aaron, we've discussed the sectoral restrictions, which are there. We've discussed a little bit about the data protection bill. Where do you see the trend of the government and the sectoral regulators towards data and general privacy compliances?
Sure, thanks, Josefa. And we saw one or two questions, relating to that as well. In the last few years, whilst we've had a very basic set of data protection rules, from 2011, and we've had the right to privacy judgment, now as a fundamental right a few years ago. We've had a lot of debate over the last 3-4 years over a proposed law. Now, in a way, a lot of this has diverted our attention from reality, right? That reality is that a lot of the industry regulators are proactively prescribing data specific regulations in their respective sectors, and there are so many examples to go by. MeitY, every year, a couple of years, releases new guidelines that government ministries and government agencies need to follow when procuring IT services, right? That prescribes a data localization requirement, extensive audits, data security measures, right? Taking a cue from where Varsha stopped, there was also a Disha or a model law. There was also the e-pharmacy rules, both did not see the light of day, but even there were extensive data provisions, including localization requirements to store the data in India. Take the insurance sector, which is a massive sector in India, right? The IRDI has been very proactive in prescribing data localization requirements, data retention requirements, for a minimum period, restrictions on data sharing, because in insurance, you have different entities from the insurer itself to TPAs to hospitals and medical practitioners. So there are provisions on that. The RBI prescribed data localization from 2018 itself. It says that all payment systems data cannot leave the country, except for very limited circumstances. Telecom is an age-old industry which, continues to have localization. So engaging with a telco, will, come with certain restrictions on taking data outside. And we're looking even into the framing of new laws, right? For instance, the RBI is looking at, revamping the entire framework for digital lending, and the digital lending space is absolutely booming, in India, with microcredit, and finance and small loans. Even in the proposed law, data localization was prescribed, that data handled by these kind of, apps, digital loan platforms, all of that, right, would need to be stored on servers within India. So the mindset of the regulators appears to keep, these kind of sector specific sensitive data stored, within the country. So that is one, trend that we've seen right across the board. If I had to point out another one, and I'll conclude on this, it's on data breach reporting, right? Now, this was something, we have very basic rules from 2013 that's only certain incidents. It's not, I repeat, it's not a data breach notification. It's more of a cyber security reporting, right? But what industry regulators, like the RBI, the IRDI, all of that have been proposing in all of the circulars that they, prescribed, is to notify the regulator in case of a breach, in case of a data breach, right? So that, if you take into account with the new law that's coming, that you need to go to the DPA, right? Now you'll also have to go to the industry's regulator as well as, the DPA, right? So these things need to keep in mind, and they will, work in harmony with each other. In fact, there was the DEPA as well, which was by a consortium of the RBI, the Securities and Exchange Board, the insurance regulator, the pension fund regulator, and this was supposed to be implemented in the fintech space, in the medical space. Again, very restrictive provisions on data, including reporting, localization, storage, all of that. So definitely a more consumer friendly, a more secure, approach, being taken by the industry regulators, which has been the trend over the last few years and is definitely set to follow regardless of the proceedings on the data protection bill.
No, this future approach of the government and the regulators, the insights which you gave, Aaron, are very helpful. I think the key takeaway for our audience and our participants is that, while of course, as Indrajit also rightly pointed out, that the data protection bill is knocking on the doors, will become law, but irrespective of that, sectoral restrictions, conditionalities, and compliances are here to stay. I think that is the underlying theme and takeaway, which is extremely important, for all of us, irrespective of whether it's the fintech space, irrespective of whether it is the healthcare space, irrespective of whether it is the M2M telecom space. And more importantly, we are going to spend the last couple of minutes and over to my colleague Aniruddha, who's going to give us quick insights as to what do the MAP laws in the country look like, and are there any sort of sectoral regulations there? Over to you, Aniruddha. Okay. I think, our colleague Aniruddha has some sort of a technical snag. We can't hear him, but let me kind of give you a quick download on the MAP laws. So geospatial and MAP laws have been in India for several years, but more recently in February 2021, there was complete liberalization of the space which happened. The past restrictions in terms of exports, processing, digitizing, all was superseded by the new guidelines which came in. Which has treated Indian entities, foreign companies, Indian foreign-owned controlled companies in a large manner, giving them equal rights and obligations. However, there are some key nuances which I would like to talk on, especially in relation to processing of a certain data which is of a finer value. And the finer value of data has been detailed under the MAP policy. There it is very clearly identified that such sort of data, which is of lesser than the finer value, can only be created, owned, stored and processed in India by Indian entities. And Indian entities are those entities which are either owned by Indian nationals or controlled, by Indian residents and nationals. So this is a very interesting sectoral regulation which is there. While most of it is liberalized, but data of finer value, our audience should be aware. And just one more quick point again, in terms of an activity restriction, which is again very unique to the geospatial laws and geospatial map sector, is certain activities such as terrestrial mobile map surveying, street view surveying, and surveying in Indian territorial waters shall be limited again to Indian entities. So short point being that these two restrictions, would apply to any 100% owned Indian subsidiary which is owned and controlled by foreign companies, which cannot be done. So the short point being that if you are dealing or handling any sort of data in the geospatial map space, be very careful that one, how was the data collected? That is critical. And second, what is the value of the data in terms of finer value? Because these restrictions, would tend to kick in. And if they kick in, there are certain limitations in terms of how you can use them. The short point being that if you are licensing these sort of finer value data or data collected from these operations, there are further restrictions and you cannot store them on your servers, and you can use them through API plugins. So these are the complexities which apply to each of these sectoral regulations. And let's take a few of the quick Q&As which are there. I think there are a lot of questions, and some of these questions have also been answered by my colleagues. Let me kind of pick up the RBI one. There are a couple of questions in terms of the RBI data localization fintech solutions which are happening, and how does it pan out when it comes to the federal law. So the short takeaway on that is that irrespective of the DPB coming out, the sectoral regulations will prevail, because they are slightly more onerous, and the genesis and the thinking is that the DPB is going to be the base law, and of course the sectoral regulations can add in more compliances. I think the next question I'm going to hand it over to Indrajit. Indrajit, one of friends, Adhit Kulkarni, he's saying that, do you think that the Chris Gopalan committee report for governance on NPD was largely ignored by the JPC, considering how a different data protection authority was proposed for NPD? So quick insights would be great.
Sure, Josefa. And I think the operator word here should really be ignored. I think they're cognizant of the fact that the ministry itself had sort of taken the initiative of setting up the Chris Gopalakrishnan committee, and they had submitted their report sometime in September of last year. So I believe there is that sense of awareness of the JPC as well. But I think the way they looked at the provisions relating to NPD under the Data Protection Bill was more in the nature of an enabling provision, a foot in the door, that sort of justifies perhaps an eventual legislation that could be enacted subsequently basis the recommendations of the Chris Gopalakrishnan committee, is my read on it. That being said, I think, again, within the government, there is a clear demarcation of the purpose of why, say, clause 92 of the DPB dealing with non-personal data sharing has been included. And they perhaps see that as data sharing for the limited purposes and utilization by the government itself, whereas the Chris Gopalakrishnan committee's recommendations extended more to the creation of high-value data sets for use by a wider bucket of entities, and sort of develop an open data sharing platform on the basis of all this NPD that is collected and shared, and through data trustees and other mechanisms that the Chris Gopalakrishnan committee report delved into.
Absolutely. I think one last question, and then I think we can conclude. There are a couple of points, Aaron, on the whole tokenization and the June 30th deadline. So very quickly, if you can just recap, what is the June 30th deadline read with the whole tokenization theme?
Absolutely. The June 30th deadline is for two compliances to come into place. One is that the merchants and the PSPs cannot store card data going forward, right? Second is that by June 30th, the existing card data need to be purged and erased. Now, to work towards that, tokenization is one such solution, to implement. Let me make a distinction here. The June 30th deadline is only for the data storage restrictions and the purging. So tokenization, these kind of solutions are not mandatory, right? They are only suggested by the RBI to put into place in order to ensure business continuity.
Thank you. I think this clarifies the couple of questions which were raised on this subject. I think as the team has also tried to respond to most of the Q&As. If any Q&As are still outstanding, feel free to write to us. You have IDs on the invite, and we would be happy to respond to them. On that note, thank you so much. Thank you to all the panelists. The session was extremely insightful, and I think the big takeaway to all our participants is that while we await the DPP, please do not forget that the sectoral restrictions and compliances on data are already existing, and it may keep evolving. So on that note, we will bid adieu, and thank you all for your time. Have a good day. Bye-bye.